to the charge sheet feels that the company should also be prosecuted for some offense committed by it under the Indian law. Can it not be done?
It can be.
Suppose at the stage of section 319, also after all the evidence has come, can the court not exercise the power to arraign an accused against which there is material evidence brought during the inquiry and trial, and the company is also an offender? So you have to build those arguments.
Supplementary charge should be amendment.
Section 319, also after all the evidence has come, can the court not exercise the power to arraign an accused against which there is material evidence brought during the inquiry and trial, and the company is also an offender? So you have to build those arguments. So you think over these lines, Samvita?
Yes, Your Lordship. The admitted position is that, Your Lordship, that the company has not been charge sheeted or not been made accused, Your Lordship. That is the difficulty. I completely understand. And the section one judgment, Your Lordship, 2016, volume 3, judgment once. I just like to show para 31 of that judgment, Your Lordship.
No, in what that judgment is in relation to which act?
That judgment is in relation to Arbitration Act, but the purposive construction, the Honorable Supreme Court has defined the entire thing of the purpose. The object can never be of the enacting section or inserting section 9, subsection 5. Subsection C can never be to exclude certain things, or it has to be given a purpose. What was the purpose behind of the legislation to insert the provision 9, subsection C in the enactment? And the purpose is very clear, Your Lordship, to exclude those persons against who are involved in such kind of activities. Be it the company, be it the director, be it the individual.
Oh, no quarrel about that. But in that case, provisions of the same law, Income Tax Act, treats all these 4 or 5 categories as separate persons.
From
Person.
My lord, may I submit one line, my lord?
Yes.
My lord, 9C have got two categories, two groups, I would say. One in relation to tax area and prosecution. The second group, no tax area, only prosecution. In the first category, my lord, the declarant who is filing a declaration against a tax area and facing a prosecution, assuming myself that there would have been a tax area for which I filed declaration and there is a prosecution launched against me or instituted against me. That is coming in the first category. The second category, in respect of non-income tax cases. If your lordship would see, Income Tax Act is not there. If your lordship would see D, Income Tax Act is not there.
Not
E, Income Tax Act is not there. But if your lordship would see A, tax area coupled with prosecution under the Act. So these are two distinct things, my lord. Now take for a while, your lordship, 319 power. The court exercises 319 power of CRPC and arrays the company as an accused. Take for a while, your lordship. In that situation, the person should have been arraigned or prosecution should have been instituted on or before filing a declaration. My declaration is already filed. Whatever will happen thereafter.
but
That we understand. That all those nuances we understand, Mr. Kurmi. We do not observe allowed on unnecessarily what is not required to be observed. But what we generally have observed is to ask for the purposes of the respondents' counsel to answer and to prepare on those aspects.
You argue on those lines.
I will be, Your Lordship.
You must have understood the query of my lord.
I have understood, Your Honor, and I know the difficulty, Your Lordship, which is being faced, Your Lordship. I can understand that difficulty. The difficulties in my part also, Your Lordship, because the charge sheeted, the Income Tax Act has not been made. And the immunity under Section 6 of this enactment deals with the immunity with respect to the company, directors, firms, but with respect to the offences under the Income Tax Act. And for that particular purposes, under Section 9, subsection B, C, D onwards, the Income Tax Act, the provision of income tax has not been there, Your Lordship. Only the other offences are there apart.
That is your failing, no? You could have launched a prosecution against the company and could have excluded him from the category under 9D.
Again, I will be saying, Your Lordship, the purpose was different, Your Lordship. Maybe that's the legislation purpose was different, and that's the reason it was not included. However, in 9C, the class of person which were declared as ineligible was only with respect to the class of assessment years. Person are not being made ineligible under Section 9, subsection A. The assessment years are being made for that particular assessment year, they are not being held to be filed. And
Entitled to file, eligible to file.
eligible to file. Only the assessment year are being excluded in 9C. However, in 9,
Maximum they can take 9 lakhs, even if you consider the second revised as illegible. Because
We give you time to come better prepared.
Yes, Your Lordship. Just one thing, Your Lordship. So far as second declaration is concerned, that is, in my view, it is not a revised declaration but a fresh declaration for the purpose Circular 21. I have also given, Your Lordship, wherein Circular 21
Yeah,
last.
that
Have you also prepared a kind of a
written notes.
written notes like the petitioners council?
No, I have not, Your Lordship. I will be giving that. I will be
So
giving that.
you do it step by step, A, B, C, D, whatever propositions from your side,
I will be giving that.
supported with legal reasonings and any provision or judgments which you want to support it from.
Ji, I will be.
So we then keep it, say, on. Last week में बड़ा busy हो गया है ना, कुछ मोटे बंदर GST
30 तारीख
28
28 को वाला था। 28 को तो है,
28 को तो सब GST
जीएसटी वाला है, उसमें एंट्री मॉडल को मॉडिफाई करना है। 30 तारीख को 30 तारीख को ज्यादा नहीं है, 30 वर्चुअल है।
We'll keep it on 30th March.
Yes, Your Lordship.
That's
So far it is a virtual day.
virtual day.
वो ऑर्डर हो जाएगा तब तो।
Can it be
Mr.
on,
Kurmi?
Your Lordship, can it
Yes.
be 6th of April? I will have a discussion also with the officers at till 31st March. They all are packed with the time barring assessment and all. So a discussion could not be. Can it be on 6th of April, Your Lordship?
Yes, it can be. But by that time, we may again have to be recapitulated.
It's a short. I will try in my written argument. I will try to bring also of the things, Your Lordship.
In these matters, the Revenue Council should also come with proper written notes. Learned Council for the Revenue, Ms. Amrita Sinha has advanced her submissions. However, she seeks further time. Stop. Let the case appear, as prayed for, let the case appear on 6th April. Mr. Kurmi,
My
suits
lord.
you.
My lord, it suits me, my lord.
Very well. 6th April 2020.
Much obliged, Your Lordship.
Obliged, my lord.
Here is item number 24, WPC number 133 of 2013. Mr. Rakesh Kumar for the petitioner, Savi Kumar Verma for the response.
Lords, I am appearing for respondent in this matter, my lords.
Yes, yes. So today, what is the position, Mr. Tiwari?
Here for the railways,
Yes.
and I have filed a interlocutory application, your lordship.
Yes. To bring on record additional documents.
Yes, your lordship, these are very much essential for the just decision of this case, your lordship. And it was originally, I think, not filed in the WPS.
So, Mr. Verma, you file a reply to this,
Lords,
whether it
Some of the documents are already on record, my lords. By way of IA, I have earlier filed some of the documents which is re-annexed in this IA, my lords.
Very well. So, you don't deem it necessary to file any objection to these additional documents?
No, my lords, I want that case is finally be decided, my lords, because the respondent is going to retire and he is time and again requesting me to get it finalized, my lords.
So, we should allow the IA today, and then have you, both of you, given us a short list
और
of
हम
dates.
भेज दिए हैं हुजूर. I have already sent it on 22nd of February, my lords.
These are the documents.
Mr. Tiwari,
Your Lordship, in the IA, my case is set in the IA itself. All the relevant papers are in the IA.
no, any list of dates, synopsis that
That
you also
that
want to send?
that we have not sent, Your Lordship. But if Your Lordship grants me time, I'll.
You want the judgment to be set aside, so it is your duty more. He only has to defend the judgment of the court.
I will file the short synopsis, Your Lordship.
IA number 1621 of 2022 has been preferred by the petitioner to bring on record some additional documents which according to him are necessary for adjudication of the dispute, though it could not be brought on record earlier due to inadvertence. Stop. When counsel for the petitioner, Mr. Mahesh Tiwari, submits that the documents are very much relevant and necessary for proper adjudication of the case of the parties. Stop. Therefore, they may be allowed to be brought on record. Stop. Then counsel for the applicant shall respondent does not have any objection to the prayer as according to him some of the documents are already part of the pleadings. Stop. On consideration of the plea of the petitioner and the submission of the parties, IA number so and so is allowed. The documents IA shall be treated as a part of the record. Stop. Let the case appear on 22nd March 2022. Stop. Respondents, counsel for the respondent has sent a list of dates to mail. Stop. Then counsel for the petitioner shall also submit list of dates, a synopsis containing short synopsis, including his own list of dates, at least 2 days before the next date of hearing. Very well, we have it. I have a different bench.
May I please, Your Lordship?
Just a minute, let sister also join.
Pranam, Lordship.
Pranam, Pranam.
May I please?
Our telephone is number 84 second one, will now be GP number 21621. Just will be top of the
Uh, in this case, the applicant, Mr. Sameer Kumar Singh, was admitted to CMC Vellore, Your Lordship, on 27, and on 28th of February, he was tested COVID positive, and thereafter he is in isolation. And I talked to their guardians at the CMC Vellore. They said because of isolation, they are not suggesting, and they procured the current state patient. But as per their knowledge, on second angioplasty was done, Your Lordship, on 2nd of March. So this is a current situation.
Angioplasty.
Angioplasty on second. So on telephonic instruction, and as they said, the doctor has said that on 2nd of March, angioplasty was done, Your Lordship. But I said, kindly procure the document so that they can be produced before Your Lordship. But they contacted with the CMC authorities, and they said, you will get all the documents. So my prayer is that more time.
Lordship, on the interim order was passed on 19/1/22.
Yes, sir.
What did you do for
Your
for
Lordship,
more than 1 month?
Your Lordship, CMC Vellore was not ready to take leadership, and even we are not able to get the train reservation. As we got the appointment from CMC, we moved. That's why it got delayed. He released from the jail on 22nd of January, and thereafter he admitted to CMC Vellore on 27th February.
Went to Vellore on 27th February.
No, he went to Vellore. Before that, he admitted to Vellore, CMC Vellore on 27th of February, and on 28th he was COVID positive. So, on further treatment has been delayed.
So, angioplasty for angina has been done on 2nd March as per telephonic instruction.
As per telephonic instruction, Your Lordship.
And 1.5 month period is going to expire when?
It has already been expired, Your Lordship, but bail on 22nd of January.
23rd of January.
Yes, on 19th January, Your Lordship has passed the order,
Ah,
and 22nd of January.
1.5 month provisional bail was granted.
Yes, Your Lordship.
So when has that expired, or when is going to expire?
It expired on 6th of March, Your Lordship. I has filed on 5th of March, Your Lordship.
IA was filed when?
5th of March, Your Lordship.
4th, 5th of March. So has he surrendered?
No, Your Lordship, he is in CMC Vellore in isolation, undergoing treatment.
Why did you file it just on the penultimate day? You should have sought an extension. Otherwise, he is without any court's order continuing beyond the period of provisional bail.
Your Lordship, we are trying to procure the documents. We don't procure documents, so filed late.
So once the angioplasty is done, maybe in 10-15 days he would be fit to come back.
Quite possible, Your Lordship. Quite possible. If he can get negative, Lordship, I'll procure all the documents and place before Your Lordship what the treatment is going on, because not to show Your Lordship what the treatment going on on telephonic instruction.
We can extend it for another 15-20 days, sister, so that he...
Yes, Lordship.
IA number 1793 of 2020 has been preferred for extension of the provisional bail granted to the appellant by order dated 19 January 2022. Stop. The interlocutory application was filed on 5th March 2022, one day before expiry of the period of provisional bail. Stop. The delay in filing was on account of delay in procuring the treatment papers of the petition appellant, who is admitted in Christian Medical College, Vellore, as per the medical report at an C series. Stop. And counsel for the appellant submits that as per telephonic instruction, appellant has undergone angioplasty for the for treatment of triple vessel disease, stable angina. Stop. He may be allowed extension of provisional bail for suitable period so that he can recuperate and surrender. Stop. Then counsel for the informant is also there,
Yes, Your Lordship, I'm here.
and the state are present. Stop. We have considered the submission of learned counsel for the parties. Stop. On consideration of the reasons stated in the instant IA and the statement made by learned counsel for the appellant, provisional bail is extended up to 25th March 2022. On the same conditions, appellant should surrender on or before 25th March 2022 and file a surrender certificate. Stop. IA stands disposed of.
Along with all medical reports, Your Lordship. That was the previous order also.
Supplementary with medical reports. You file that.
Obliged, Lordship. Much obliged. Thank you, Lordship.
Very well, sister.
Pranam Lordship.
I heard your speech yesterday. It was good and very, very incisive. So far as speaking for the
Lordship,
problem.
I thought that peripheries are not important. The core is important.
That was a perspective. So
I spoke from my heart, Lordship.
it appeared to be.
And I have interacted with many, many females very closely, which they might not have deposed confidence in maybe many others. Very closely, Lordship, very closely I've seen. I've seen this very, very closely, Lordship. Lordship, this NDA program can be taken off.
And
This giving training to rural girls, preparing them for NDA entrance. Because NDA is primarily physical fitness, and they are physically fit. And I'm sure that something can be done from Jalsa on this line. Some army personnel.
Today I read in the newspaper that from primary classes onwards, this state government has allocated 16 crore funds for giving sports equipment and different sports like football, badminton, even for the primary classes, some
Lordship,
toilets.
to share with your Lordships on this, as your Lordships are very much aware as to what kind of life there is in army and what kind of training is actually required. The training which is required, these sports teacher will not be able to give. And
retired army personnel, if they are employed as physical instructors in at least the high schools,
yes, Lordship,
and +2 schools, I can tell you that in our school, Ramakrishna Mission, we had an ex-army personnel. In fact, the first, as we used to call our teachers, Bharti Da, Da we used to say, every teacher.
Yes, yes.
He was himself a Lance Nayak, and after he left, he joined Netherhart School. Thereafter, Mr. B.D. Singh joined. He was also an ex-army personnel, Naib Subedar. So they have all the training of physical instruction and sports both.
Yes.
They used to play with us also, volleyball and other things. Of course, not cricket, but volleyball, football, etc. They knew how to. And they used to do the referee job also because they were
Oh.
very well conversant with
Multitasking.
rules of the game. I
Lordship,
know.
the government taking steps will be delayed, and through Jhalsa, such kind of program, if possible, because army personnel are available everywhere. They are
No, no,
available. And
that system.
I have tried to in Simdega also. I was trying to find out. All the time they say that they should be given some honorarium. This is what their demand is. They do not say that a full-fledged salary is required to be given. They say that at least some honorarium should be given to us. So that,
Standing.
and I'm sure, Lordship, that girls in Jharkhand, if they are inducted, the entire social fabric will change in 10 years. 10 years down, otherwise also, Lordship, they are leading the family most of the time. They are the bread earners at times.
And the state has produced so